Awesome. Well, thank you all for coming. For those of you who are currently on, welcome to an update on evolving discrimination laws with attorney Jim Reidy of Sheehan Phinney. We're really excited to have him here and cooperation with us at the New Hampshire Lodging and Restaurant Association. Jim, if you'd like to introduce yourself further and go into what we're going to talk about today.
Great, thanks so much. So welcome everyone on this sort of rainy Tuesday morning, and or for those that are watching later, whatever the weather is when you're watching it. But as we're in the sort of the beginning of spring and the beginning of what could be hopefully a busy season for lodging and restaurant related businesses. And I think that there are a lot of issues that come up, but one of them we want to talk about, and next month we're going to talk about this too in a separate webinar, is youth employment. But one of the issues that's not unique to youth is the issue with regard to discrimination. And we're going to talk about that today because the EEOC, which is the U.S. Equal Employment Opportunity Commission, has targeted restaurants and related businesses with regard to youth employment because they consider them to be potential targets for workplace discrimination. But again, it's not unique to them because it could be a much older worker, it could be someone in the midpoint, and the bottom line is that discrimination claims are still very much an issue in the workplace. And as we come out of COVID, there is also an issue with regard to just the sensitivity that employees and applicants have in the workplace. For those that are watching this, I'm sure you've been in business for some time. The law continues to evolve. Our culture continues to evolve. And with that, the rules seem to change a bit. But what doesn't change is basic civility, basic respect, and basic fairness in the workplace. However, there are some things that have changed, and we're going to talk about that. So at any point, if you have any questions, you can go to the Q&A section, and Samantha is going to help in that regard. I'm happy to answer any questions as we go along. So the title of the program is It's Only Funny Till Someone Files a Lawsuit, an update on evolving discrimination laws. And I can tell you that I've been in this field for now going on 34 years. And all I've ever done is represent management, and all I've ever done is a labor and employment law. And in that period of time, I've seen significant changes, but there is a constant theme that runs through it as well. And I said, again, that's civility, respect, and fairness. So we'll talk about that. We'll talk about some of the new developments. We'll talk about some of the tried and true methods for protecting your business, protecting your employees from potential claims. And just basically, again, nobody wants to spend time with lawyers and in lawsuits or with agency investigations. You'd rather just do whatever it is you do, whether it's lodging, whether it's hospitality, restaurant businesses and the like. The margins are so tight that I'm sure nobody has an extra couple $100,000 kicking around to spend on disputes like this. And plus also these disputes are disruptive. They tear at the fabric of an organization. So my recommendation would be, if you don't have a policy, certainly look at a policy, do training, take these matters seriously, and we'll talk about some of the issues that you should consider going forward. So many things have changed over the last few years. There's no question about that. And I think one of the things that you would think that discrimination claims would have decreased during COVID because businesses were shut down. People were not coming into offices or workplaces, but unfortunately that was not the case. Now, there's one correlation, by the way, that between a traditional correlation, and that is between unemployment numbers and discrimination claims. Typically when unemployment is low, and unemployment continues to be low in this economy, and you know that all very well, that it is issues related to vacant positions, high wages, great mobility between workplaces and so on. So we're at 2.3 to 2.5% unemployment, full employment being 4%. Nationally, we're at 3.6% unemployment, again, below the full employment number. So you would think that discrimination claims would drop off because people have options. They can go from one place to another. They can if they feel harassed or discriminated against, they can move on. But what we've seen still a steady number of discrimination claims. And the question is why? Well, with remote work, people were doing things electronically that they shouldn't have been doing, and so on. So let's go to some of the numbers. Between fiscal 18 and 21, so that's what EEOC, the U.S. Equal Employment Opportunity Commission, and the state agencies track numbers by fiscal year. And this is a snapshot of a few years. They received almost 100,000 charges of discrimination. And a charge of discrimination is one where someone contacts the agency, they have a complaint, they go through the process of filing it, they have to file it within a specified period of time. And it's usually within 180 days of the last event of discrimination, or if there's what's called a dual filing, where you file both under federal law and under state law, you've got up to 300 days, which is 10 months. So it's a relatively fresh complaint filed with the state agency or the federal agency or both. It goes back to the employer and the employer has to respond. Almost 100,000 claims filed during that period of time. And if you look at that, almost a third of those were sex harassment or claims of sexual assault. And it involves all sorts of issues in that regard. And the assault could be verbal or physical. So why do we still have so many of these claims? I mean, sex harassment has been a part of the law for over 40 years, yet, we still have these claims. And I think in part, you can credit the hashtag Me Too movement of a few years ago, because many times victims suffered in silence, or as I said a minute ago, or they just moved on. But here they felt the victims feel a bit more empowered and feel like they could have a voice and that there could be change if they stay and file a claim, or they file a claim and move on. So I think that's a good thing. And I think things have changed. And if you look at that, hashtag Me Too did raise consciousness. And so as a result, there was a survey done by Society for Human Resource Management that said that 1/3 of executives surveyed said that they've changed their behaviors. Executives have changed their behaviors and the behaviors of the organization to avoid perceived or actual or perceived claims of sex harassment. That's a good thing, because oftentimes you might have a tone deaf CEO, CFO, members of the C-suite, manager, supervisor, and so on. But there's 1/3 survey said that, yeah, they've become more aware of things not to say, things not to do, comments not to make, and so on. That's a good thing. But of course, the question is, but what about the other 2/3? And again, I mentioned a second ago, did you know that 1/3 of all sex harassment claims involved electronic communications? The number is actually higher than that. It's actually between 1/3 and 1/2 of all claims. What does that mean? Well, people have devices that they use, and or their laptops or their computers, and we've become a society that's plugged in, and so we send these messages. Of course, you've all heard about sexting, sending pictures and the like, but it's videos, it's messages, it's texting, and so on. So between 2021 and 2022, more sex harassment claims involved remote workers, both victims and harassers. Now, again, during that period of time, we had a lot of people working remotely, and only about 50% of the American workforce that was remote has actually returned, at least on a part-time basis, to the office. But again, it shows how plugged in we are, and perhaps as clueless as we are, because it's like that old shampoo commercial. You tell two friends, and so on and so on and so on. Shampoo commercial is something I know a great deal about. But the issue there is that when you send it to someone else, you think, well, some senders think that's as far as it's going to go, but it's an electronic record, and it could be then forwarded to someone else or just simply preserved. And oftentimes, and I'm sure you've sent emails or texts before, where the recipient doesn't understand context, and oftentimes that is a problem too. Now, sometimes the context is perfectly clear, something saying something that's highly inappropriate, or a message or an image, and so on. But other times it's just simply a misunderstanding. But the bottom line is you have a victim or someone's upset and they make a complaint. Sex harassment and retaliation claims are among the most common in the workplace. And if I had to ask you, what do you think the most common are, year after year after year, they basically are race discrimination. Now, that's not necessarily as much of an issue in New Hampshire, but it's changing because of our changing demographics. But race is an issue throughout the country where it's more diverse. but sex harassment is either number one or number two. In New Hampshire, it's number two. Then you have other forms, disability and so on. Number one is retaliation, nationally and in New Hampshire. Retaliation. So what is that? Someone complains or someone participates in an investigation and they feel like either something actually bad happens to them, they get fired, they get demoted, they're not hired, they're frozen out of the organization, or they just feel that way. They feel that they become a pariah of some sort. A retaliation claim, as I'll discuss in a few minutes, is as potent or more potent than the underlying discrimination claims, because underlying discrimination claims, oftentimes they are how the person feels, but you can have a tangible issue. He said this, or she said that, or I was touched, or I was assaulted. That's tangible. Retaliation, this is how I felt. So it's a dangerous issue. We're going to talk about that too, because the way in which as an employer you respond and monitor afterwards is going to be critical to reducing your risk of a retaliation claim. And remember, when they talk about sex harassment claims, it's not necessarily about sex. It could, meaning doesn't have to be a sexual act. It could just simply be, I'm treating you differently because of your gender. And again, remember, gender has a different meaning now. It's not just male, female. It could also be based on sexual orientation, or it could be based on gender identity. And don't assume that a harassment complaint can never happen to you. The numbers are increasing. And again, the sensitivity, and perhaps for very good reasons, the sensitivity has changed, or the willingness of someone to come forward and file a complaint. Here's an example. Recently, EEOC, again, the U.S. Equal Employment Opportunity Commission, and this one is out of Boston, sued a company that owned and operated McDonald's franchises in New Hampshire and Vermont. The lawsuit alleged the company knew or should have known, and that's called constructive knowledge. You knew or should have known about the harassment employees. It was a night shift manager that allegedly subjected teen workers to inappropriate touching, offensive comments, and physical threats. As a result, EEOC settled that case, meaning they brought the claim, but after some degree of litigation or back and forth, the parties settled for $1.6 million. That's a lot of money. And I know it's a franchise and I know it's McDonald's, but still spread over the various restaurants, that's still a great deal of money. And what also came out of that was a requirement that their management had to go through new training, and there were other updating their policy, new training, and monitor. And they had to enter what's called a consent order, which is EEOC still remained involved to make sure that there were real changes. Now, sure, you can fire a manager, but the question is whether you have some sort of systemic or cultural issue you also need to address. But that was big. And again, that underscores the issue I opened up with, which is you can have an issue wherein you have older managers and supervisors and seasonally younger workers coming in. And now they may be mature or immature younger workers, or you could have a manager who's just a little bit older than the others, and they don't have the sense or maturity in the workplace in dealing with others. And the informality in many workplaces can sometimes lead to, on the one hand, team building, on the other hand, potential inappropriate conduct. So, of course, the question is, but we have a policy, is that enough? Well, a policy is certainly good, and that's a good starting point. And there are many policies online, and you should have an up-to-date policy, which we can talk about. But no, a policy itself is not enough. It's a good starting point for, one, having rules of conduct in the workplace, two, having a defense. We have a policy, but in fact, you need more. And it means you have to breathe life into it. And because if you have a policy that you don't follow, the claims could actually be more costly because they suggest you didn't take it seriously, the policy that is. So again, wait a minute, we had so many people working remotely. What's the problem? Or businesses were shut down. Well, claims went up. And again, the claims went up and it was because, again, you've got this tension in general, I would say. COVID created a sense of anxiety in all of us, economic, with regard to our healthcare, with regard to our loved ones, with regard to our healthcare system and the like. Sometimes discrimination claims are based upon the fact that I can't do anything about what was happening out there. I may have a personal issue, I may have a family issue, I may have a financial crisis. But if something is offensive to me, or it is something that truly should be addressed, then that's something potentially I can do something about. So whether it was virtual or in person, we've seen an increase in the last 2 years. And it is something that employers need to be aware of and need to guard against and hopefully address. So what does that mean? Well, when you have a policy, you've got a couple of things that you benefit from. One is hopefully you prevent the bad conduct because you've created a sense of awareness and clear expectations as to performance. You also have a reporting system in place that says that if you have a concern or complaint, this is who you go to. And a proper policy should have at least 2 places where someone can file a complaint. Why is that? Well, one is availability, but the other is, what if the person you're supposed to complain to is someone that is not approachable? Or worse yet, is the person who is the offender, the harasser. And some people are more comfortable talking to a man or a woman or someone that they can identify with. So reporting, make it clear who you report to and that and how it's done properly. Then compliance. Some laws, like some states, rather like Massachusetts, require you maintain a policy, and there's a model policy that I have here. New Hampshire doesn't require it, but of course it is a very good idea. And one of the things you handle, and I've handled hundreds of these cases in New Hampshire and beyond, is the first thing you show, we have a policy. And then we did training to support that policy. And we can show that it was an effective complaint procedure because people did come forward. And that's the liability issue. If you maintain and enforce a policy, can help limit your legal liability. Let's go back to that issue of you knew or should have known. Well, if you have a complaint procedure in place and it's an effective complaint procedure, you say, well, this is the first time we've heard of it. And there was many ways in which he or she have come forward and they didn't. So we're not liable until we were put on notice. And the way in which we can be put on notice is this policy. Again, you have to show it's an effective complaint procedure, but that could limit liability. The legally protected categories I mentioned earlier, because it isn't just about gender. It could be race, color, national origin, age, religion, sex, sexual orientation, gender identity, pregnancy, genetic information, physical or mental disability, marital status, or military or veteran status. Those are many of those are protected under federal law. Most of them are protected under federal law. All of these are protected under New Hampshire law. So how has the law of workplace harassment and discrimination evolved in recent years? Well, for those that are familiar with the show Mad Men, you know that we're no longer in a workplace, thankfully, where people are, one, smoking in the office, two, holding a martini in their hand and chasing their secretary around their desk. I mean, are there sexual assaults? Is there inappropriate behavior and touching and so on? Yes, that still goes on. But it's evolved to, again, keeping up with technology, to sexting and cyber assaults. And again, there are more protected classes than before. It's not just male and female, it's also sexual orientation, gender identity. And again, I mentioned skyrocketing claims are the retaliation claims. And now there's a new claim called pretaliation. This is brand new. Retaliation, what is that? Don't even bother coming forward, because if you do, you'll be singled out as someone who's not a team player. You'll be singled out as someone who doesn't fit in this organization, that you don't get it. This is who we are. For goodness sake, we have a putting green. You can pour yourself a beer here. We're very relaxed, and so on. It's like, but it also suggests that you may not be receptive to a discrimination claim. So it's called pretaliation, a brand new concept, which is, yeah, I've got a policy, but we really don't mean it. So do harassment policies cover all of those protected classes? If they don't, they should. What does that mean? If you took something off the internet, even 5 years ago, it's probably not up to date. So talk to your counsel, your legal counsel, if you have them. You can look at model policies, but especially if you're in a state like New Hampshire that has more protected classes than under federal law, make sure that you actually update your policies to include and define what you're talking about by way of protected classes and updating your, what if you had two people in the organization, you identify them, by John and Mary, but John's left the organization and Mary's been promoted. Well, you want to update that as well so they know where to go, or it's an email or a phone number or something that they know where to go. And what if you have late night shifts and the person who's in charge of receiving the complaints is not on duty? You want to make certain that you've got someone on duty who can handle those complaints. Hopefully, this is a familiar definition for you. And this is a definition you've probably heard many times before for purposes of defining what sex harassment is. And it talks about unwelcome advances, requests for favors, nonverbal or verbal comments, physical conduct of a sexual nature, submission to a request or rejection of a request end up in an adverse action, something bad happening to the person. Or more importantly, because the first one is the first two are quid pro quo. The next one is one you see most common. That's the hostile environment. Conduct that has the purpose or effect of unreasonably interfering with someone's ability to perform their job or creating that intimidating, that's the retaliation, hostile or offensive work environment. That's the one we see most common. And again, it is not just about sex. It could also be about race. It could be about age. It could be about religion, and so on and so on and so on. So your harassment policy, in other words, is not just about sex. It should be, generally speaking, it should be a conduct policy, a professional conduct policy. You can define this, and you should define it this way, but you should also say it also applies to every other form of protected classification in the workplace. And what does that mean? Well, that means in New Hampshire, if you've got 6 or more employees, all of the state discrimination laws apply to you, 6 or more employees. Federally, it's 15 for most classifications, unless we're talking about age, which would be 20. But that would be most of you folks, if not all of you folks, would be covered at least by state law. And we talked about the proper elements of effective harassment policy, a clear statement of what is a legally protected category and what conduct will not be tolerated, and an explanation of what will happen if you violate the policy. You define what harassment is or misconduct. You define the legally protected bases, and you can provide examples of prohibited conduct. And so what am I talking about there? Again, it's physical touching, it could be offensive conduct, it could be inappropriate joking, it could be sexting, it could be inappropriate images, treating someone differently because of their membership in a protected class, or complaints, or participation in an investigation, and so on. And by the way, if any of you are looking for sample policies, just reach out to me. My contact information is at the end. I'd be happy to provide those to you. The elements of an effective harassment policy, again, clear reporting process that provides accessible avenues. And again, what we're talking about here is we're talking about at least 2 places where someone can complain, that you don't limit it to a supervisor or other chain of command. It's many ways in which a person can complain. That complaints do not have to be in writing in order to go forward. In fact, as a supervisor or manager sees something, truly, if you see something, say something, and meaning the person may not have come forward, but you've seen it, and now the organization is on notice as a manager or supervisor. Avoid saying things like, if you don't report it within 30 days, it's no good. Absolutely not. You encourage them to come forward as quickly as possible. But some people, again, going back to #MeToo, may not feel comfortable coming forward. Again, don't require them to be initially in writing. At some point, they will be reduced to writing, so you have a snapshot of what is it you're exactly complaining about. But that is not an impediment for the complaint to come forward. It could be as simple as, I don't feel comfortable with, or did you see what just happened? Did you hear that? Or recently, I want to put you on notice as to something that's been happening here you may not be aware of. That's the beginning of the process. It should be as easy as possible. And you make it clear that employees who experience this, or observe this, meaning it doesn't have to be a supervisor or manager. If someone else sees it, they should bring it to your attention. And it basically says that we'll protect confidentiality as much as possible. However, you can't promise absolute confidentiality, because in order to conduct an investigation, you have to be able to say, I've got to talk to other people. However, it's on a need to know basis. And then you have to provide assurances that you won't be retaliated against for bringing forward the complaint in good faith or participating in the investigation. And then finally, we're going to take what the law requires is a prompt and appropriate response. A prompt and appropriate response. So what does that mean? Does that mean immediate? Pretty close to immediate. Does it mean, well, it's a busy season, we'll get to it eventually? Not at all. Does a law prescribe or require a certain amount, meaning 24 hours, 48 hours, 72 hours, and so on? No, but the cases basically come down to say a prompt and appropriate depends upon the circumstances, but really for the most part, you should be able to get to it within a couple of days, 1, 2, 3 days. And it all depends upon the circumstances. A prompt and appropriate response. What is appropriate depends upon the circumstances, but certainly prompt is prompt. And then the remedy, which I'll talk about in a few minutes, is again, depending upon the circumstances. You're going to tailor it to the circumstances involved. What do you do about statements about false accusations? Well, you have to be very careful because that could be that sort of retaliation issue. You want to say, we encourage you to come forward because again, even if the person says, I felt slighted, and you may say, that's not what was intended and we've investigated and it was not intended to be sexual or offensive and the like, and it's resolved, you still want that person to come forward. The other thing to point out, and this is an important point, if the person comes forward in good faith, and even if they're wrong, that it didn't constitute sexual harassment or any other form of discrimination, if something bad happens to them as a result of filing the complaint, they've got a real retaliation complaint. In other words, if the underlying discrimination complaint is somehow dismissed or deemed to be legally deficient, they can still file a retaliation claim. So you have to be very careful about that. But what happens when you have a truly false statement, a false accusation? Somebody made it up, and it does happen. It doesn't happen very often. Oftentimes it's a misunderstanding or a misunderstanding with regard to context. But when it does happen, then you can deal with that. But you still have to say all complaints come in and we'll deal with that, and then it will be a prompt and appropriate response. But I can tell you, I've done hundreds of these cases, and very few are truly made up or false. It could be they've been exaggerated. It could be they misunderstood, but very few is actually a false statement or one that is truly intended just to, effectively extort money from the employer. So how does having a policy help for liability? And I mentioned that, help prevent the claims, increase the likelihood that the matter will be reported internally and therefore could be corrected, as opposed to filing it with a court or an agency or getting a lawyer involved on the outside and so on. It shows that you take it seriously and you can take reasonable steps to prevent it, and also protects you from what's called a punitive damages claim. And what does that mean? So the damages in these cases, if they're successful, could be lost wages, what's called back pay from the point of judgment back to when the harassment occurred, front pay from the point of judgment going forward to when the person can find a comparable other job, and attorney's fees potentially, what's called compensatory damages, which is mental suffering associated with the event and the process. And then punitive damages. Punitive damages are, you've got a bad acting employer, you've got a bad acting manager, supervisor, owner, and the like. And because of that, the agency or the court can assess punitive, punishing damages. It's meant to sting. So if you've got a policy that is effectively a workable policy and you genuinely invest in it and you take it seriously, does that mean you're not going to have any complaints? No, but it reduces your likelihood of a punitive damages claim because you did try to prevent this matter from happening or try to resolve it appropriately. How do you distribute the policy? Well, it should be written, but you have other ways you certainly should have it posted in your workplace. And that would be in a meeting room or common area along with other workplace postings. You can have a hard copy in your employee handbook. You can have it electronically posted, emailed, but you have to have some form of proof that you have it both posted in your handbook and also that employees knew through onboarding. And is it one time is enough? Meaning I hired you, that honeymoon period when someone first comes to work for you and they're just constantly signing papers and everything's hunky-dory. sometimes employees do not remember what they've signed and so on, or if that's the one time that you discuss that along with your dress code policy, your non-smoking policy, your attendance policy, and so on and so on and so on. They may not remember it. So periodically updating for employees and reminding them, and that where that could come about is again through training. And how do you breathe life into your policy? You educate your staff, you train your managers, critical. Your managers are your eyes and ears, but they're also potentially your Achilles heel. And again, underscore that case from that McDonald's franchise. Critical that you have, and that was a night shift manager. That doesn't matter, it could be a manager at any time, but you want to make certain that they, on the one hand, that they're your eyes and ears, that they are receptive to complaints, they enforce your policies, they breathe life into your policy. They know about your policy, they breathe life into it, but also they don't violate the policy themselves. And if they see something going on, just like any other coworker, but most importantly as a manager or a supervisor, if they see it, they address it and they bring it to the attention of others in the organization that can hopefully address the matter before it becomes a bigger issue. And that's the workable complaint procedure. And how do you test it? Well, you test it to make sure that people, through training or otherwise, you know where to file a complaint. And again, once the complaint is filed, it is a prompt and appropriate response, which depends upon the circumstances. But again, factor in that 3-day rule and a reasonable resolution. So what does that mean? That means that not every case is the same. Well, if it's sex harassment, we have to do this. We have to suspend, then terminate, and so on. Not necessarily. The offense and the resolution are related, meaning that whatever the conduct is or whatever the problem is, and however many people it affects and however long it's been going on and how serious it is, that's how you determine what the appropriate response should be. And then the critical part, all those are important, but then you monitor afterwards to avoid retaliation. And what does that mean? That means basically you say to the person, this is how we've resolved it. Now, the victim doesn't necessarily dictate what he or she thinks you should do. They can suggest, but ultimately you decide as the employer. But even then, just simply say, going forward now, if there's anything else in connection with this matter, you have to know where to notify us. And that way, if you're monitoring it and you've told them, come forward if there's anything else, again, you should limit your liability in that regard. And hopefully you won't have a recurrence of that same problem. So training, again, training all employees regularly, train your leaders, supervisors, managers, and so on. Ensure that they understand the words of the policy and the intent behind the policy. And they understand the need for them to address and stop the issue. Teach them how to do that. What does that mean? It isn't just I'm the supervisor of the shift and what I say goes and that's it. And and you certainly don't have a situation where it's and upper management doesn't need to know about that. That is not what happens. They are part of upper management and they share that information. But then consistent enforcement of the policy. What does that mean? Again, doesn't mean that every response is the same, but consistency is a prompt and appropriate response. And I will say that supervisors and managers are also accountable for their action or inaction. And they understand what they have to do as far as their reporting. If they see it or hear of it, notice it, how they're supposed to bring that matter forward. That's managers and supervisors, but it's true of all employees too. Use live. I prefer the interactive training if you can, because then you can truly have the back and forth with the individuals. You can have good eye contact and the like. But when you can't, you can do online training and so on. But again, I prefer that you folks do with a trained professional, lawyer, HR consultant, whatever agency person that they do this training, and they should have your policy in hand that they can refer to. So it's tailored to your organization. The benefits of training are you raise awareness. You talk about what is offensive, what is unwelcome, what is welcome. You remind them that I was only joking is not a good defense. And also that off-duty or off-premises conduct could affect the environment. What do we mean by that? Both the underlying issue, meaning if someone is sexting or texting after hours, well, it didn't happen here, so it's not my problem. No, if it's related to work, it could be your problem. Or said another way too, if there's retaliation, someone complained here, but then the employees typically socialize after work, and now that person is frozen out. There was a case involving the Santa Fe Railroad, and that was deemed to be retaliation, even though it was involved outside of work activities, social activities, and that can be dangerous. So I think you want to, again, remind folks that, especially the victims, if there is a problem here or otherwise, you are to let us know after the resolution of the matter. Again, you're going to talk about in your training, workplace civility, respect, and professional conduct. And you're going to also talk about bystander issues, meaning if someone who's not the victim sees what's going on, they're to bring that matter forward, even if they're not a manager or supervisor. And while you can't broadcast the outcome of an investigation, you can basically talk about ways in which you can address it globally. But you can certainly tell the victims and the alleged harasser what the outcome has been and what you're going to do in response. Again, management training is absolutely critical, and that's especially true for seasonal and if you've got youth workers. They're deemed to be a vulnerable population, and EEOC is focusing on them this year as a part of their 5-year strategic plan. So this question comes up all the time with regard to sex harassment training in particular. So can I still hug someone in the workplace? And the answer is, it depends upon the individuals. It depends upon the circumstances. You don't want to have a serial hugger, but on the other hand, there's a death in the family. There's someone just had a baby. There's a big birthday. Being careful about birthdays too, people's sensitivities about certain ages. But can we have that level of informality or familiarity, I should say? And the answer is yes, but it depends on the circumstances, the individuals, and so on, what their comfort level is, and how well they know each other. But what about, speaking of knowing each other, what about relationships in the workplace? Can you allow employees to date? Can you allow coworkers to be married? And the answer is yes. You can't really prohibit relationships because people typically meet their significant other or their next significant other in the workplace. That happens. So it's hard to police that, of course, and it's kind of in some ways silly to police that. However, should a manager or a supervisor be married to or in an intimate personal relationship with someone they're supervising? Well, no. That's when you might have a problem, because others might feel slighted, others might feel like there's favoritism. Or what if that relationship ends, and relationships end all the time? Then you might have a problem there too of some sort of retaliation afterwards, or worse yet, workplace violence, but we'll deal with that in another session. So the answer is, as long as they're not in a direct report relationship, generally speaking, relationships are relationships. Just if it becomes something that's not consensual anymore, or something that is coerced, the individual has to know, meaning the person who feels that pressure has to know where they can complain. So what you're saying is don't hire young people anymore and don't allow any dating or any romances in the workplace? Not at all. You just have to be careful, be aware. A new topic for training is something that comes from a new law in New Hampshire, and that would be it is a misdemeanor to send an unsolicited image of oneself, and you can read the rest there for purposes of engaging in either just in showing various degrees of undress or other activities. It's a misdemeanor. Well, even before the New Hampshire law came out with that, which was effective in January of this year, I would say that would have been a violation of just about any policy. So one, if they're using a company device to send these pictures, and by the way, to be clear, if they're using your computer system to send a text or an email or an image, it is actually not a violation of federal law or state law for you to monitor your computer activities and to discipline those who misuse your computer your computer systems. But what if they're using their own personal device to send that? Well, it's no different than really just reaching out and touching someone or saying something highly inappropriate. If they're using their personal device or otherwise their computer equipment to send these images to an employee and it affects their employment, then it could be and should be a violation of your policy. That's assuming when the recipient doesn't consent to the receipt of that image. And sadly, people do that all the time. But by the way, if there's consent initially to a bad joke or conduct or relationship or even receiving an image, but then the person no longer thinks it's funny, no longer thinks it's acceptable, and so on. Does the original consent cancel out their objection now? Not at all. Does the person who's in the workplace who suffered in silence or seems to joke along with them or seems to not stand up and say, I object, is that person not a victim? Not at all. Because the courts have basically lined up and said that you could actually have someone who suffers in silence who didn't feel comfortable coming forward or appeared to go along with it when in fact they were suffering in silence. So you have to make it clear that that all employees should feel comfortable coming forward. And again, something like this should be one of the main things you include in your training and even in your policies. So have you heard enough? It's like one of those late night Ronco commercials. Wait, there's still more, because that's the retaliation part. Retaliation is it's illegal under federal and state law. It's for, again, it is for someone filing a complaint or supporting or assisting another person who files a complaint. It requires an adverse employment action based upon the person's either filing the complaint or participating in the investigation. And what does that mean? That means, again, getting fired, getting demoted, not picking up shifts, not getting a raise, or just simply being frozen out in the workplace. Those are all forms of retaliation. And it's, again, has to be related to the underlying complaint. Causation and timing are important, meaning if the person complained in 2007 and then they were fired in 2023, you don't have any connection there. If it was, I filed a complaint in the last couple of months and then something bad happened to me, then it's close enough in timing. And the question is it related to the underlying complaint or investigation, or is it something different? Meaning if someone were to complain about something, but then they punch out a coworker, or they're chronically absent for other reasons, or they don't follow policies and procedures, if that's the reason for the termination or the discipline, then you break the causation chain. But you have to be careful in that regard. And the other thing is being careful about off-duty conduct. And I mentioned the Santa Fe Railroad case, and that was a woman who complained about sex harassment in the workplace. 2 people were disciplined as a result, but afterwards, her coworkers treated her differently and did no longer invite her out after work to go for beers and to go bowling. And the Supreme Court took that on and said, yeah, that could be, because it seemed to be related to her complaint and the resolution of that complaint by the company. Then the Thompson case was a fiance, a male, dealing with the sex harassment of his betrothed, his female partner, and again, gender identity and sexual orientation doesn't matter. They're in a personal and intimate relationship, and they had worked for the same employer, but he worked for a different supervisor. He was upset because her supervisor allegedly sexually harassed her, then he felt that the company was not responding to it in a prompt and appropriate fashion. He got disciplined and he filed a complaint. And the statute refers to other aggrieved persons, and he was deemed to be an other aggrieved person. And so the Supreme Court dealt with that. Now, again, these 2 are people that were engaged to be married and they were cohabitating. And of course, the question is, okay, so what does that mean? In order to have a retaliation claim that involves someone who was not the victim, but had participated in the investigation and had complained about the conduct, and forget the participation in the investigation, just basically stood up and said, what's happening is inappropriate and you ought to fix it, and the company's not fixing it. Is that enough? And the court said Congress has to address that, and they have not in the last couple of years. But for now, we'll tell you it has to be more than a casual relationship. So what does that mean? In that case, again, they were engaged to be married, they were cohabitating, and that was certainly more than a casual relationship. And how about father and son? Well, there was a case in the First Circuit said, yes, that's obviously more than a mere casual relationship. What about best friends? And a court in that case said, no, that's not enough. So that Thompson case was an interesting development in this area. So what does the law require? Again, the law requires you've got a policy, that you take it seriously, You have a complaint procedure and there's a prompt and appropriate response. And then you monitor afterwards to avoid retaliation. And so the supervisor's role in that, and this comes up in training, see something, say something, don't go it alone. You're involving HR and other members of management. As soon as you know about it, or you think you know about it, it's as if the owner and the CEO knew about it at the same time. Time is of the essence, prompt and appropriate response. Being discreet, meaning you're not broadcasting the issue, but it will be on a need to know basis, but you have to respond. Be part of the solution, not the problem, meaning you don't make matters worse. Avoid the backlash claims, retaliation, and you monitor afterwards. And this is an important one that comes up for purposes of managers and supervisors. A supervisor, if he or she is the bad actor, he or she could be individually liable. What does that mean? That means if they retaliate against someone who files a complaint, the company may be liable, but they may be individually liable too, which means the employer may not have to represent them because they've got divergent interests. And I don't know many managers and supervisors that have a lot of extra cash around that want to shell out to a lawyer to defend them or to pay damages to a victim. The other thing is there was a New Hampshire case that a few years ago that actually was very interesting. So it typically individual liability relates only to retaliation. However, there was a New Hampshire case that said the underlying discrimination, an individual could be liable if they depart so much from their role as an employee and they act in a bad faith manner. That was an individual who owned a company who was found to be liable for the underlying sex harassment and discrimination, in addition to retaliation. So that can be very expensive very fast. And so the key is in training to mention that as well. Mistakes to avoid, the obvious, ignoring the problem, dismissing it, failure to act in a prompt and appropriate fashion, say, well, it's not my department, it's not my supervisor, not my employees, I'm not going to deal with it. Again, if you're a supervisor or manager and you see it or you hear of it, you have to bring it forward and follow up because the clock is ticking. And again, avoiding retaliation afterwards is so important. So I know I talk fast. I know that your time is precious as well. I hope this has been helpful. I hope it's been a good reminder and also give you a few updates as to some new developments in the law. Samantha, is there anything that's been out there? Any questions from folks?
So I had a couple sent directly to me, and one was, do you have any tips for handling what you believe to be a truly false claim?
Yeah, good question. And I think the answer is, if you think it's a truly false claim, the most important questions you can ask in an investigation, this is going to sound so silly, but it is time tested by me many times. Who, what, where, and when, not why. Who, what, where, and when. And usually based upon that, you can get to, wait a minute, that story doesn't line up. That doesn't make any sense. So-and-so wasn't here at the time. That didn't happen. We have videotape evidence to show that that didn't happen, or audio or whatever. And then also who else was involved, because who was in the area, we can talk to them. It doesn't line up. And the other thing you can ask in an investigation, this is something I ask at the end of every investigation, is there anything else I need to know? Because that way the person doesn't say, well, you never asked me that. No, I have that open-ended question. Is there anything else I need to know? Based upon who, what, where, and when, talking to other people, checking other independent evidence, you can get to, well, actually, that's not true. So what do you do in that regard? You have to proceed with caution, because again, the person may have believed it was true. But if you truly find out it was absolutely fabricated, then yes, you can terminate the person. But you have to be very, very careful in that regard. And I definitely say seek legal advice before you terminate someone based upon what you believe is fabricated information, truly whole cloth made up and with some sort of malicious intent to either harm the employer or harm someone else within the organization. Because many times it could be just simply a misunderstanding. So just be careful in that regard. But if it's truly made up and truly false and you can prove it's fraudulent, then you can certainly terminate someone's employment.
Awesome. Another question that was asked was, because you had referred to the Santa Fe Railroad case a couple of times. How would you handle the off hours conduct in a situation like that?
Good question. And so the answer is, I do think it is a challenge, and I appreciate that question, because how do I control who people associate with after work, and who could be friends with someone? And that's almost like saying, if someone unfriends you on Facebook, is that an actionable issue? Because people do get offended by things like that. The answer is, you say to the person in that case, the victim in that case, if there's anything else we need to know, and if anything else happens, just let us know. So they got together as a group and they went out afterwards, the coworkers, and she was excluded from that. Because the Supreme Court said in that case, it originated in the workplace and it found its way elsewhere. And also that freeze out from the bowling and beers activity made its way back into the workplace too. That could be a form of discrimination. So it's a factor involved. So what you say is, to those involved, there is to be no retaliation, no freeze out, no misunderstanding, no misdirection, no effectively no bad action, because what this person did was they brought forward a complaint, which is what we encourage. We had corrected the problem. Now let's get back to work. You can't require that people socialize, but if they freeze someone out because of their good faith complaint under your policy, you remind folks that they could be disciplined if they retaliate against someone. Now, what that gets at is, it's human nature. If you're accused of doing something wrong and you don't believe you did something wrong, your nature is going to be, well, forget that person. I'm not going to deal with them. I'm not going to socialize with them, or I'm not going to be nice anymore. Or, you know what? I'll be robotic. I'll just say, hello, good to see you, and just get about business. I'm not going to lower my guard because, apparently I was misunderstood. That is so hard, because that could be a form of retaliation. So, the problem is, it's human nature when you're accused of something. Even if you did it or didn't do it, you still have sort of effectively the same reaction. So I think you have to be careful in that regard. But I think what you do is you say to the victim, make sure if there's anything else we need to know as we've resolved this matter, you bring it to our attention. And then with regard to the others involved, there's to be no retaliation, and you explain what that is. That's about as good as you can get.
Awesome. And then I had some questions about templates for harassment policies for New Hampshire.
The next slide up is my contact information, and I'm happy to send along some template policies. Again, remember, if 6 or more employees, you're covered by state law. 15 or more employees, you're covered by state and federal law. 20 or more employees, you're covered by, you add age discrimination under federal law as well. But even at 6 employees, you've got age discrimination under state law. So if you reach out and contact me, and my contact information is right there, I'd be more than happy to send along some template policies. And then again, you just tailor them to your organization.
Awesome. Well, I think that is it for the questions, unless anybody else had something they wanted answered.
And I'll just share, as we're wrapping up here today, I want to thank my partner, Jen Meckel, who has done work with me and on her own with regard to Lodging and Restaurant Association members. And she was helpful in providing some of the information for these materials. So happy to help. Thank you for your attention today, or whenever you're watching this program, and look forward to our next presentation, which I think next month it's going to be on April 18th, and it's going to be issues under federal and state law with regard to youth employees. So Samantha, thanks for taking your time today, and all you folks, and have a great day.
Thank you. I look forward to the next one.
Thanks so much.
Bye.